Welcome to Division 2 of the Court of Appeals. My name is Judge Lipinski. To my right and your left is Judge Daly, and to my left and your right is Judge Furman. We have two cases set for the 1:30 docket. The first case is People v. Carey. I understand one of the attorneys will be appearing remotely. The second case set at 1:30 is the Rinker v. Colina Lee case. We'll take a short recess after Carey before we entertain arguments in the Rinker matter. We then have one case set for the 2:30 docket, and that's the case of Wilhoit v. Industrial Claim Appeals Office. Are the attorneys in Carey ready?
Yes.
Have both of you received a copy of a handout of our procedures? Let me just note, because of the nature of some of the cases being argued today, counsel are directed not to disclose the names of victims or relatives of victims. Today's arguments will be live streamed. If anyone in the courtroom has a cell phone, please make sure it's turned off so it doesn't interrupt us during the oral argument. Let's begin. So we'll start with People v. Carey, and the appellant may begin.
Good afternoon. Malika Magner, registration number 27149 for defendant appellant John Carey. May it please the court. Because of the number and complexity of the issues involved in this case, I'm going to address the first issue unless the court has any questions about the other three issues. Mr. Carey's waiver of his right to counsel was not knowing, intelligent, and voluntary, where the trial court failed to conduct a conflict hearing after Mr. Carey explained that he did not want to be represented by appointed counsel, despite the court's understanding that one had in fact been held, and where Mr. Carey raised issues sufficient to trigger an inquiry by the court without the presence of the people and in the presence of both Mr. Carey and trial counsel.
Did you raise, counsel? Can you
Yes.
see me? Okay. Did you raise the position about having to have a hearing outside the presence of the people in your brief?
Well, that is the structure of a Bergerud hearing. A Bergerud hearing is an inquiry
Did you raise
outside the presence.
Did you raise that the hearing was not held outside the presence of the prosecution in your brief?
I did not specify that.
Thank you.
The people argue that the court repeatedly inquired into the reason for Mr. Carey's dissatisfaction with counsel. But in fact, on more than one occasion, the court stopped Mr. Carey from explaining his issues that he had with counsel because of attorney-client confidentiality, which would have been explored in a Bergerud hearing. One, clearly in anticipation of a Bergerud hearing, and another, again, the court stopped Mr. Carey, citing the attorney-client privilege. After Mr. Carey first raised the issue, while the court asked Mr. Carey a brief initial question, asking him if he wanted substitute counsel, on all subsequent proceedings, the court insisted that Mr. Carey either proceed with the Office of the Public Defender or proceed pro se. The record shows that after that brief initial mention of substitute counsel, the court never again mentioned that option. And while the court initially told Mr. Carey that it would conduct a conflict hearing out of the presence of the prosecution if he was alleging a conflict with his attorney, it did not do so. And on subsequent occasions, the court referenced, yes, Your Honor.
What was the conflict, counsel? What was the conflict?
The conflict was a breakdown in communications. Mr. Carey repeatedly told the court that he was unable to communicate with counsel, that he was in the dark regarding his defense, and that he had not received his discovery. Yes.
on what issues was there a conflict other than Mr. Carey's request to be able to review the discovery materials in jail?
The issue was that he had no communication with his counsel, that he didn't know what the defense was going to be, that he was completely in the dark, and that counsel simply had not communicated, and that counsel had not interviewed witnesses.
Didn't that primarily focus on discovery?
Well, a complete breakdown in communications is certainly a ground for substitution of counsel, and that's what Mr. Carey raised here.
But it seemed to me that the record revealed that Mr. Carey wanted to review discovery and keep
Yes,
that in the jail,
absolutely.
and that really was the sum total of the dispute, of the dissatisfaction. Was there other evidence or anything in the record that shows something other than that?
Yes, absolutely. Mr. Carey repeatedly said that counsel had failed to communicate with him, that he didn't know what his defense was. Had counsel spoken to Mr. Carey, it wasn't necessary that he review discovery in order for counsel. Yes, Your Honor. Oh, was that a raised hand?
It was a raised hand, but you know what? I think I ought to allow you to finish your statement.
And part of the crux of the problem here is that because the court repeatedly stopped Mr. Carey from explaining his issues, that's why we need to have a Bergerud hearing. Mr. Carey tried to go into more details about what his issues with his counsel was, but on 2 occasions at least, the court said, nope, that's attorney-client privilege, we can't get into that. So we don't have the full record that a Bergerud hearing would give us.
Counsel?
Yes, Your Honor.
Okay. In your reply brief, you cited several different statements that you indicated, or you thought indicated complaints broader than the discovery issue. Some of those, at least, seem to have been connected to the discovery or actually made in the context of other comments with the discovery issue. And the other ones, there was no attempt at any elaboration beyond what had been previously said. Doesn't that all seem to say, as a matter of common sense, it led back to the discovery problem?
No, I disagree. The issue of discovery is the receipt of actual documentation. What Mr. Carey was complaining about, of course, if he had received his discovery, he would have had more input into his case. But what he was saying was that he didn't know what the defenses were. Counsel had not shared with him. Yes.
Didn't he at one point say, well, the defense has nothing to do with what really happened? Doesn't that indicate he did have some type of defense position?
We don't know the answer to that question because this searching inquiry, which is required, was not conducted by the trial court. Had the trial court done so, this appellate court would be able to fully review Mr. Carey's claims. Yes.
At some point, he never asked originally for substitute counsel. He asked to represent himself, and at least initially, because they would not leave discovery with him at the jail. How is that denying him in any way his right to counsel?
Because the way that the system is set up is that either, yes, of course, a defendant has the right to proceed pro se. However, Mr. Carey wanted to be represented by counsel. When the court initially made a very brief statement, do you want to, if you want to be represented by substitute counsel, we'll have a conflict hearing, etc. The court didn't, other than that brief initial statement, the court didn't offer Mr. Carey the opportunity to have substitute counsel. We cannot presume that Mr. Carey knew that substitute counsel was the appropriate choice that he had.
Could I, sorry to interject, did counsel think Carey was dissatisfied? Is there anything in the record to suggest they thought there was a problem?
Well, when asked by the court whether there was a conflict, counsel said no. But it's not enough for counsel to simply dismiss their client's issues. The court needed to conduct the inquiry. The court needed to have the two of them out of the presence of the prosecution in the format of a Bergerud hearing, which was set forth by the Colorado Supreme Court, in order to answer these questions.
Can there be a breakdown in communication where the attorney is giving good advice to the client, consistent with law, but where the defendant is seeking to present an argument that's contrary to law, as appears to be the case here regarding the defendant's wish to have the discovery maintained in jail?
Well, we don't know what advice counsel gave to Mr. Carey. We know that counsel said that he didn't think that there was a conflict. He said that they didn't need to give him discovery, which was correct. But Mr. Carey complained not only of the discovery, it was the trial court who latched on to that aspect of Mr. Carey's complaint rather than listening to Mr. Carey. Yes, Your Honor.
I apologize, counsel, for interrupting you, but it seemed from reading the record that Mr. Carey was fairly adamant that he had to do it his way because he had to have discovery at the jail so that he could dissect everything. So to the extent that Mr. Carey could be characterized as adamant, I'm not sure how the fault gets put on the trial court.
Well, the trial court itself believed that a conflict hearing was appropriate. The court itself indicated that it had held one and therefore was not going to be holding another one. The trial court, having listened to Mr. Carey and listened to trial counsel, believed that the Bergerud hearing requirement was in fact triggered. It was only through oversight that the court did not in fact hold one. The question is, at what point is the searching inquiry demanded by Bergerud necessary? Once a defendant raises issues that would establish one of the reasons for the appropriate appointment of substitute counsel, then the court is required to then conduct the additional searching inquiry outside the presence of the prosecution, at which the court can question both the defendant and trial counsel. That did not happen here. And we know that with respect to one of the other issues in the case, the raising of the mental health, the mental condition defense, that was not raised by counsel at the appropriate time at arraignment. So there was a strategy disagreement.
But didn't
Yes, sir.
Mr. Carey advise the trial court on June 11, 2015, that he had no history of mental health problems or mental health issues?
As part of the Arguello advisement, yes, the court did ask that. But, of course, the court, on its own motion, subsequent to that, did in fact require a competency hearing based on its grave concerns for Mr. Carey's decision. So the trial court, who was in the best position to see the demeanor of Mr. Carey, felt that Mr. Carey had mental health issues.
But not that he was insane.
Well, we don't know that because, one, going to the second issue, the court did not allow him to interpose the insanity defense that he had asked for pre-trial. Therefore, Mr. Carey did not present any evidence of that. Yes, sir.
He used the word insanity, I believe, 2 days before trial. That's not a very timely plea of not guilty by reason of insanity, is it?
In this case, it absolutely was a timely plea to the extent that it was interposed after arraignment, but it was interposed months before trial. Mr. Carey repeatedly raised the issue of his mental condition. The mental condition defense is a subsection of the insanity statute. Yes,
Go
sir?
ahead, go ahead.
The mental condition defense was moved into the insanity statute. The court was well aware that he was raising a defense under that statute. In fact, the court had ordered the evaluation that was necessary for that defense. Yes, sir.
I'm not sure how the claimed mental condition would qualify under insanity when essentially the condition was, as I understand it from reading the record, was I don't know how to act in society because I've been in prison most of my life, and therefore I have a response that's triggered as a result of having my prison experiences. Why is that not the express accepted conduct, accepted, EXCEPTED, conduct accepted from the insanity statute?
Because the trial court refused to allow Mr. Carey to enter the plea, we don't know what evidence would have been presented at trial had the court allowed it. And Mr. Carey raised the issue repeatedly. On that one occasion, that is what he said. But on other occasions, he talked about his mental state at the time of the offenses. But the court precluded him from raising the defense. Therefore, we don't know what would have been raised at trial had the court appropriately found good cause for Mr. Carey to raise the defense post-arraignment.
Thank you, Counselor.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Brian Lanny. My registration number is 47486, and I represent the people. I do want to respond to a list of things, but first I want to begin by emphasizing that Mr. Carey was not asking for substitution of counsel. And I would draw the court's attention to the first motion that he filed, which was a pro se motion while he was represented by counsel, and that motion he is seeking to represent himself. He's not asking for a different attorney, and he provides the reasons that he's seeking to represent himself, and the reasons are that he is not being permitted unfettered access to his discovery, and that the jail's policy is that he cannot access the law library if he is represented by counsel. So I think that motion very clearly at the outset, this is not a defendant who's asking for a different attorney. It's a defendant who's asking to represent himself. I agree that when he came into the court after filing that motion, what the court did first and foremost was ask to clarify, are you looking for substitution of counsel? And the court explained that the court said, I'm trying to understand whether you're asserting a conflict and you're seeking substitution or whether you're seeking to represent yourself. And the answer was Mr. Carey was seeking to represent himself. And again, at that point, the reason was that he had only been able to review part of his discovery, not all of it. I don't agree that that was the only time that the court explained or made clear that substitution of counsel was something that could be on the table. The court did that again on the day of defendant's express waiver of his right to counsel. And that was, I believe, June 18th. And this was after the court's given its second Arguello advisement. And this is the moment when it's accepting defendant's actual express waiver. And the court then again explains to him, I'm going to find that, and this is after many times they've discussed the problem between himself and counsel, and over again, the problem is described the same way. And at this point, when the court's accepting Mr. Carey's express waiver, the court again says, I'm finding there's absolutely no conflict between you and the public defender or his office. There's no well-founded reason for me to consider appointing another counsel. The only conflict is the discovery issue. And it again puts that on the record. And Mr. Carey doesn't dispute that characterization at all. So I think it's fair to say that if there was this larger looming problem that at these multiple hearings had never been placed on the record, at that point, Mr. Carey would have said, that isn't the conflict, counsel is ignoring me, or whatever else the conflict is, and that's not what happened here. So I think at least twice, it was made very clear that substitution was another option here, and that simply wasn't what Mr. Carey was looking for.
Did Mr. Carey express he didn't know what the defense was or something along that line that would be more foundational?
He did. He said that more than one way. I think at one point he said he was in the dark. And at
Okay.
one point he said he doesn't know what his defense is. And that was early on. I mean, I would just point out that was, I think this was 2 months from his arrest, or 3 months from his arrest. So I don't think it was inherently unusual that at that point there wasn't a solidified defense. I don't know, but he did say those things, Your Honor. And I think when those things are selectively clipped out of the record, it could be argued that it looks like he's asserting a total breakdown of communication. But when you look at the record as a whole, that's not what he was asserting. And also the record shows there wasn't a breakdown of communication, because the record shows that he and counsel were communicating. For example, in the first hearing where Mr. Carey is given an arguello advisement, he's ready to waive his right to counsel, and the court is urging him to think about this and talk to the public defender one more time, and he reluctantly agrees to do that. And he comes in the next week, and he's met with counsel, and he describes it as a long, productive conversation. And in the end, what he says to the court is that it came down to one thing, and it was unfettered access to discovery, and if he couldn't have that, he had to represent himself. But I think this record shows that counsel and Mr. Carey were communicating. The record itself shows it.
But wasn't there a breakdown of communication as well on the issue of the insanity defense?
I don't agree, Your Honor, that the record supports a breakdown of communication on that defense. I guess one piece of that is that, which I think is the crux of my argument with respect to the second issue, is that insanity was, despite what Mr. Carey labeled it on 2 days before trial, that's not what he was asserting. I disagree with the argument that the court interrupted him and never allowed him the opportunity to explain what this defense was. Many times in the record, which I cited in my brief, I think Mr. Carey explained what this defense was that he was calling insanity, and it wasn't insanity. It was that he believed his wife was in danger, and when he went there to rescue her. And there was this other piece of, I've been in prison, so I respond to things a certain way. And that's not insanity. So I don't think I think the law is clear that the issue of whether good cause exists to enter an NGRI plea the day before trial doesn't turn on what the defendant is labeling his defense. It turns on whether there's been a showing of any support for the defense at first, and second, a showing of good cause for why it wasn't raised. This issue wasn't raised even in the first time there was any mention of, I think what he said was impaired mental condition. That I think happened in July. So that was a month after Mr. Carey was pro se. I also think there's the issue of, even if he disagreed with counsel about strategy prior to that, that's not grounds for substitution of counsel. I mean, disagreement over strategy, the defense counsel is the captain of that ship, and I really think to the extent there was anything more than this disagreement over discovery, it was a disagreement over strategy, and that also is not a basis for substitution of counsel. And I think that we see that later in the record, and that's when Mr. Carey states that this is the first time he does assert that there was a conflict with the public defender. This is many months after he's waived his right to counsel, and he explains that the conflict was the defense they came up with has nothing to do with what happened. And that just confirms for us that what the disagreement here was was one other strategy.
What did he say the conflict was many months later?
The defense that the public defender came up with has nothing to do with what happened. And he
And
said,
as well as also the public defender's rules and regulations.
correct, that was the other piece of that, Your Honor. And so I think that that statement from the defendant really just reaffirms what I argue is already clear from the record in June and July when he's getting these Arguello advisements. And it's just consistent that this was not a defendant seeking substitution of counsel, and this was not a defendant saying anything on the record that warranted substitution of counsel. As far as I don't agree. Mr. Carey never said, as far as I recall from the record, that he was unable to communicate with counsel. In fact, I think he said many things to the contrary. I think he said things like he communicated well with counsel and he liked counsel, but the discovery issue was the wedge between them. So I don't agree that he ever expressed an inability to communicate with counsel. I want to respond a little bit to the issue about the Bergeron hearing. I agree that it doesn't appear from the record that there was ever a hearing where the prosecutor was excused. And I also agree that at a later date, the court appeared to believe it had done that. That's true, that's in the record. But my position is that doesn't matter because a hearing outside the presence of the prosecutor wasn't necessary. It wasn't necessary because defendant was placing the basis of his dissatisfaction on the record, and that's what matters. And I think there's a case that says that. I think it's Kelling says that a failure for the court to inquire into reasons for dissatisfaction is harmless if the reasons were put on the record and they don't amount to good cause, and that's what we have here. So, I guess put differently, what I think the record shows is that if that hearing had been held, it would look just like the transcripts that we do have, with defendant, again, an additional time asserting the basis for his dissatisfaction, which again would not be good cause. There's discussion in the briefs in here about the court ordering a competency hearing on its own, and it did do that, and it did do it based on its grave concerns about defendant representing himself. But what the court said, to finish the quote from the court said, "I may be very wrong about that, but I want to err on the side of caution." I don't think that the court doing that or making that statement shows that the court thought that Mr. Carey was insane. I think that the court was doing that in abundance of caution. That's what the court said it was doing. And I think because that's one half of the requirement for a defendant to be able to represent themselves is that they're competent to stand trial. And I think what the court was doing was ensuring on the record that there was a finding of competency, and that's what is on the record. And then I just want to respond to 2 points about the insanity issue. The first, I want to point out that the very first time he ever mentioned impaired mental condition, which was in July, that itself was untimely. That was well after his arraignment. So it wasn't just that even at that point he would have had to have good cause. And I point that out because I don't think good cause was ever asserted for a late NGR plea, much less at that time when he wasn't even using the word insanity.
The court didn't appear to be concerned about the lack of a good cause showing at that point.
That's correct. And I think what the record shows is that at that point, the statute, the insanity statute, doesn't just address the entry of an NGRI plea. It also addresses a defendant who is a situation where a defendant's seeking to offer evidence of a defective mental condition. And what the record shows here is that that's what the court believed defendant was doing in July. And that is why the court ordered a mental defect evaluation, which is what happened. The court did not interpret that as defendant seeking to enter an NGRI plea. The defendant never asked to enter an NGRI plea. And I think that's confirmed 2 days before trial when, for the first time, defendant uses insanity, the word insanity, and the trial court says, "You never raised that," and the trial court consults its file and explains that it understood Mr. Carey to be stating an intent to possibly offer evidence of, an impaired mental, some sort of evidence of an impaired mental condition. We don't know what that was. And the court at that time also told him he would not be prohibited from offering that evidence. But what the court said was, you didn't enter an NGRI plea. I'm not seeing any basis for you to raise insanity at this point, and you've not given me good cause, so we're not doing insanity. And to kind of dovetail on that, the assertion was made that we don't know what evidence Mr. Carey would have presented because he was never given the opportunity. Well, we do know what evidence. Well, the answer was there wasn't any evidence because the court asked him that. When this was raised 2 days before trial, the trial court said, "What do you have evidence here to present of mental condition?" And the defendant said no.
Is that what he said, or did the court ask, do you have expert evidence? Expert evidence to present, as opposed to perhaps his own testimony?
I believe that is what the court. I believe the court said expert testimony. But I think it follows then that what the court also said was that if you have evidence of mental defect, I won't stop you from presenting it, subject to the rules of evidence. And then we have a trial where, which I think, despite everything, shows that Mr. Carey, he called 12 witnesses, and none of the evidence he presented was mental defect evidence. And there wasn't any point in that trial where he attempted to bring in mental defect evidence, and the court said, "Stop. You can't bring that in because you didn't change your plea."
He did not testify, did he?
My recollection, Your Honor, is that he did not.
That he did not. And the 12 witnesses, can you characterize them into the types of testimony they gave?
Sure. To the best of my recollection, I know he called at least 2 witnesses from this reentry center where his offered defense, which he discussed many times on the record leading up to trial, and which was the defense that he presented at trial, was that his wife contacted him at some point before this incident, some weeks before this incident, said, "I've been assaulted, or I've been drugged, I've been assaulted by these people on this property." And that occurred when he was in this reentry center. And his theory was that that was what he was at. He was acting to rescue her because he believed she was in trouble. And his theory was that he was mistaken about that. But these people at the reentry center were people that he believed had interacted with his wife in ways that would confirm his theory.
And that's 2 witnesses?
That was 2 witnesses. He recalled the victims, I believe, himself to question them. And I'm not recalling with specificity, Your Honor. I know one of the last things I did before I came down here was I was looking at the page of defense witnesses, and I counted 12. But I don't believe he testified himself. Seeing that I'm out of time, Your Honors, if Your Honors don't have other questions, I will rest on my briefs for the remaining issues, and thank you.
Thank you to both attorneys for excellent arguments. The case will stand submitted, and a written opinion will issue in due course. We will take a brief recess. Rinker v. Colina Lee case. Please proceed, counsel for the appellant.
Good afternoon, Your Honors. May it please the court. My name is Jeff Cullors. My attorney registration number is 41969. I represent Dr. George Rinker, the appellant in this matter. And Your Honors, fundamentally, this case is a dispute between neighbors about a small rural roadway in Larimer County known as Galena Court. There are only 6 lots on Galena Court. Put more precisely, this dispute developed an alignment where it came down to my client, Dr. Rinker, versus everyone else, or almost everyone else, out of the remaining 5 neighbors. Things developed this way because, at least in our view, the majority of the owners on this roadway developed a disregard for Mr. Rinker's property. This disregard took the form of a drainage problem that harmed Mr. Rinker's property. To address this harm, Dr. Rinker blocked a culvert on his property, and that's how we got to having a lawsuit. One of the previous parties in this case was someone named Jason Bruin, who brought counterclaims against Mr. Rinker under the Galena Court Road Maintenance Agreement, and the counterclaims were specifically that Mr. Rinker was in violation of the road agreement because the blocked culvert was causing damage to the road. Now, I'll get right into our first issue on appeal, is the counterclaim that Ms. Colina Lee was permitted to bring. Now, this case had a long and complicated procedural history. It involved claims between Dr. Rinker and Larimer County on both sides, claims and counterclaims. Same thing between Dr. Rinker and Jason Bruin. Now, Ms. Colina Lee was made a party in that case, basically involuntarily, because Dr. Rinker had to join everybody in the subdivision in order to resolve a claim involving Larimer County. The trial was scheduled to begin on April 3rd, 2017. Ms. Colina Lee filed her pleading in this matter, which was just an answer with some affirmative defenses. She filed that in early October 2016. Again, trial was scheduled to begin that April, but in mid-March, just a week or 2 before trial, Dr. Rinker and Jason Bruin settled the claims against each other, and Larimer County and Dr. Rinker settled the claims that they had against each other. So what we were going to have was a pretrial conference on March 23rd, 2017, and that turned into basically just a status conference advising the court that all the active claims have been settled, and I think we're done, is I think some of my words to the trial judge.
How is your objection to Ms. Colina Lee's motion for leave to amend preserved if you didn't assert objections to that motion at the pretrial conference when Ms. Colina Lee's counsel made that motion orally?
Well, I mean, I believe, Your Honor, I said that I have some reasons why we disagree with that, and I believe that that was sufficient to register our objection. Obviously, we're not happy about the 11th hour amendment to Ms. Colina Lee's pleading, and I believe that was the preservation of that issue.
But you didn't indicate on the record what those reasons were. Is that correct?
I did, not at that time, Your Honor. I did, I think a day or 2 later, we submitted a request that the trial court reconsider its decision to allow Ms. Colina Lee to bring amended counterclaims, or bring counterclaims.
But wasn't it too late to raise new arguments in a motion for reconsideration that you didn't make at the pretrial conference when Ms. Colina Lee made her oral motion?
Honestly, Your Honor, I'm not sure if that was too late under the case law. I would say that that there was ample time for the trial court to consider those arguments, and that there was going to be no prejudice to anyone if the trial court did consider those arguments and reverse course.
And why didn't you present your opposition to the oral motion at the time at the pretrial conference?
I believe that would have been futile, Your Honor, and the reason why is because Ms. Colina Lee's counsel made that motion orally, and the judge ruled on that without even giving myself an opportunity to respond to that.
But then the judge turned to you and asked you if you had any objections to the oral motion, and you said that given the fact the judge had ruled, you weren't going to assert those objections at the time.
that could have been what occurred, Your Honor. I don't remember the exact words in the transcript, I'm sorry. I mean, this was incredibly prejudicial to Mr. Rinker because Ms. Colina Lee was permitted, and Ms. Colina's counsel essentially straight up said it, that we seek to step into Mr. Bruin's claims against Dr. Rinker. And these were claims that Dr. Rinker had just settled days earlier with Jason Bruin. And so instead of having an end to the case, the trial court allowed Colina Lee to basically push the reset button and start Dr. Rinker over in defending claims based on the road association agreement, claims that we had just settled, and with the result of several months more of litigation and a trial.
Let me ask you, before you leave that, counsel, how prejudiced could Dr. Rinker have been? Wasn't the new complaint essentially part of Ms. Colina Lee's answer? Wasn't it her defense? And now she was taking the very same position and simply converting it to offense, so to speak.
We didn't actually assert any claims against Ms. Colina Lee, so I was honestly kind of confused as to why she would raise this as a defense when the reason she was brought into the case was because we was forced to join her as into the case as a result of bringing a declaratory judgment against Larimer County. So that was the reason she was brought in. She wasn't brought in for any specific road condition, and so I don't believe that was a preservation of her right to then raise those claims later. And if she did want to raise those as an actual claim, I mean, the time to do that was October 6th when she filed that pleading. I mean, the fact that they were included as a defense shows that she and her counsel knew about them at that time, and yet waited until past the 2-minute warning in the second half to bring those as a claim, as an affirmative claim against Mr. Rinker. And so that's the problem with them, is that Ms. Colina Lee basically sat on them for the entire trial or the entire litigation, and then sought to jump in and carry them forward after Bruin had already secured an exit. I mean, I think this was a coordinated effort that would allow Bruin to get out of the lawsuit with a settlement, and yet the coalition, which I refer to, which are Dr. Rinker's other neighbors, were still able to preserve this attempt to preserve their claim that he was violating the road association agreement.
Doesn't the untimeliness argument also apply to Mr. Rinker's motion for leave to amend 2 months before trial, when he sought to bring in the association as a party?
Well, I agree with Your Honor. I mean, that the reason we waited we waited until at that time was twofold. I mean, at first it wasn't clear to us that the association that the road conditions were the will of the association. And second, just a few weeks before we brought that claim, Dr. Rinker asked the association for permission to do work that would fix this drainage problem. And the association disagreed with that. And so that prompted us to bring our own claims, trying to bring in the association as a party. I mean, I think that in my view, there was a lack of parity on the part of the trial judge that would allow Colina Lee to bring in new claims against Dr. Rinker 10 days before the trial had been scheduled, but not allow Rinker to do very similar to the same thing, bring in the association, and that would get all the parties that were necessary to come to a full and fair resolution of this matter to get them in front of the court.
But weren't those motions different in that Mr. Rinker was attempting to bring in a new party to join a party under Rule 19, which Ms. Colina Lee was not seeking to do when she sought leave to amend?
I agree, Your Honor. That is definitely a difference, but I don't think that means that you can't seek to bring in a new party with an amended pleading under Rule 15. Leave should still be freely given to do that in the interest of justice. And in this case, I mean, as I just explained, we had the interest of justice favored getting all the parties, getting at the root of this drainage problem, which turned out to be the will of the association. I mean, the reason we had this drainage problem is because the association had claimed control over this road, Rinker is powerless to stop the drain, to fix the road problem, to stop the drainage. He can only react to the result, the adverse result on his property. And so that's why we thought, we need to get everybody here, including the association. That's how we're going to get a just result. Now, the last issue I want.
Why did you contend that the association was a necessary party?
The reason for that, Your Honor, is because Colina Lee had brought a claim that included a declaratory judgment action which sought to interpret the association's founding document. And so we thought that in addition to the association being potentially liable for trespass and nuisance, the association was a necessary party in this litigation in which its founding document would be construed and determined. It was a declaratory judgment for that document.
Can you cite to any legal authority in which a court found that a corporate entity was a necessary party because claims in the case or proposed claims concern the interpretation of the entity's founding document?
I do not have one of those off the top of my head, Your Honor. I'm sorry. I'd like to reserve the remainder of my time unless there's questions at this point for rebuttal.
Thank you.
May it please the court. My name is Todd Rogers. I'm with Fisher Brown, Bartlett and Gunn in Fort Collins. With me at council table is Whitney Phillips from our firm, and I represent the appellee, Lori Colina Lee, who is in the gallery today. All of Dr. Rinker's arguments on appeal assert that the trial court abused its discretion in arriving at its ruling in this case. So I'll go through each of those in turn. With regard to the court allowing Ms. Colina Lee to assert a counterclaim, the transcript of the March 23rd, 2017 hearing is accurate reflection of that hearing. And the reason that Ms. Colina Lee is at that hearing in part is because the proposed settlement included a dismissal of the entire action, including whatever interest these other defendants had in the case, and under the rules, that is not proper. In her pro se, I previously assisted her under the limited representation rules. She filed a pro se answer, asserted the affirmative defense of the road maintenance agreement, and consistent with Your Honor's question, at this hearing, it became apparent that she needed to carry the ball, so to speak, with enforcing this agreement in light of the county abandoning its claim at the last minute. So this is a 2015 case. The county had initiated enforcement action. They're going along at this hearing 20 months later on the eve of trial. The parties, certain of the parties had agreed to settle, including the county, after it had vacated the road. Part of the vacation was the county's rationale was, well, there's this road maintenance agreement. These people will be fine. They can take care of it themselves. So at the status conference, we moved to assert a counterclaim, which the court, in light of the significant change in the posture of the case, as the court said, that's absolutely correct. I mean, that was a significant change. With regard to stepping into Mr. Bruin's claims, it was only with regard to Mr. Bruin's claims concerning the road maintenance agreement. There were other claims between Mr. Bruin and Dr. Rinker that are not involved in Ms. Colina Lee's counterclaim.
Counsel, did the court say that is absolutely correct before opposing counsel was given an opportunity to make his objections?
I was saying that the court was absolutely correct. The court said there was a significant change in the posture of the case, and the court was going to allow the amendment, and then Mr. Cullors said, well, it sounds like you've already ruled. I don't have anything to add. Something to that effect.
But he bypassed the opportunity to make a record of his objections.
Specifically, yes.
Is it your position that this issue has been waived and it was not reserved for appeal?
Well, I did not assert that in our brief.
Right. You assert it now.
Yes. It's absolutely not an abuse of discretion, which is a very difficult standard for the appellant. And the whole notion for that standard is these are trial court issues. And when the court is sitting there in a 16.1 case that's 20 months old, and on the eve of trial, and one of the significant parties essentially abandons the prosecution of the case, the county, which is what the county did, that's a significant change. So in other parties who were affected by that significant change, justice should allow the free amendment provided for in Rule 15.
And should justice have allowed for free amendment when it was Mr. Rinker who was seeking leave to amend?
So with, no. And that is a different situation. And although the court in its order does not specifically say this, it's in the order, in the court's findings regarding the history of the case and the fact that in Dr. Rinker's original complaint in 2015, he asserts essentially the same claims that he now wanted to assert. He asserted those claims against Mr. Bruin that he now, on the eve of trial 2 years later, wants to assert against the association.
Yeah, Mr. Bruin is gone. Why can't he assert it against the association in as much as the same thing is the county is gone? Why can't Ms. Kalina Lee assert her claim?
Well, so part of it is he could have asserted that claim against the association 2 years ago.
Ms. Kalina Lee could have asserted her counterclaim several months ago or months before that. So again, what's the difference?
The difference was the reason Mr. Bruin, one of the differences is, one of the reasons Mr. Bruin isn't in the case is that they settled their claims, okay? The exact same claims that now he wants to raise against a new and different party. So that's a significant difference than the county vacating the road and abandoning its enforcement action. So that's a difference. Bringing in a new party falls under Rule 19 as opposed to just amending claims among existing parties. That's an additional difference.
You agree that the association was a necessary party at that stage of the case?
I agree that the association was not a necessary party. And earlier in this case, before I entered my appearance, the court had addressed the issue about individual property owners enforcing the easement agreement at issue. And that was addressed by all the parties at that time, and the court said, properly and consistent with the Colorado law, yes, individual owners can enforce easement agreements in this instance. And it isn't only the association, and it doesn't have to be both of them, all of that. So So, no, the association is not a necessary party. The other thing I want to touch on is well, let me just add to the other difference with regard to Dr. Rinker's motion to amend pre-trial was, I mean, quite a while, over 2 months, from the time of the March 23rd, 2017 hearing. And at that point, the court had ruled, okay, Ms. Kalina Lee can bring her counterclaim. The motion to amend wasn't made until the end of June, and trial had been set. There were conferences before the end of June. Trial had been set for August 31. So throughout the whole case, how I would characterize it is Dr. Rinker sitting on his hands with regard to those claims, and at some point the court has the discretion to say, it's not a necessary party, it's not timely. There was nothing in connection with the motion. Dr. Rinker ordered that, well, I can just file a separate lawsuit and then we'll consolidate it.
So, sorry to interrupt. At some point, did Dr. Rinker approach the association to take care of this?
To take care
Well,
of,
to fix this, to see what role they're going to play in all this?
there has been ongoing communication between Dr. Rinker and the association through the span of
And did
this.
the association make a decision that they were not going to get involved?
The association is a group of 6, lot owners. And I'm not aware of a affirmative decision, no, we're not going to get involved, but they're aware of this case and they have not moved to intervene. With regard to Dr. Rinker's argument that the court abused its discretion in granting the injunctive relief it did in this case, I think the court's ruling is consistent with Colorado property law. The trial court cited to the proper cases.
Did the trial court refer to all 4 of the essential elements, the required elements for entry of an injunction?
The court did, 2 things. I don't think those 4 elements are necessarily required under the real property law in this instance,
And why is that?
because the cases don't require it. So if you read Upper Platte is Upper Platte versus Riverview is maybe the best case that refers to the appropriate Supreme Court precedent and goes through the various cases that when you have an easement obstruction like we do here, this is a remedy that has been recognized in Colorado. And that sort of injunction is treated differently because of the uniqueness of real estate and real property under Colorado law than if you're seeking an injunction to prohibit an employee from violating a non-compete or something. So that's the first thing. I don't think in this instance the case law requires that those 4 items be specifically outlined. But what I would say is even if that is the case, this order meets those four points for the issuance of an injunction. So the first one is success on the merits. That's clearly met. Second one is irreparable harm. That's clearly met in the real estate context because of the uniqueness of property, the ongoing nature of the problem. If an injunction isn't issued to correct the problem, the road is going to be continuously damaged and impassable.
Did the court address that point? The issue of irreparable harm because the case involved real property?
No, not specifically.
Should the court have done so? Was the court required to do that?
No, I don't think so. So I think the court properly cited to the real property easement cases that say the court has the authority to issue an order requiring that the obstruction in the easement be removed, which is what we're dealing with here. The other two elements of the four are similarly met through the court's order. It's a pretty exhaustive order, citing to the restatement third. And so even if this court thinks that the four elements should have been addressed, I think the way that turns out is, even though they weren't specifically identified 1, 2, 3, 4, the order does address those, and you get to the right result without specifically saying it. So,
Thank you.
thank you.
Rebuttal?
Thank you, Your Honors. I'd like to address a few points. First of all, the county abandoning the litigation was not some kind of thing that came out of the blue. That was the original complaint that we filed against Larimer County sought a judicial declaration that Larimer County had no authority over Galena Court because it was not a public roadway. So the fact that the county gave up, well, and also I want to point out that that issue was pending before the court via summary judgment motion that we had filed. So that was a potential outcome from the get-go of the case. That's not a proper reason for Colina Lee to basically wait in the weeds until a few days before trial and wake up and decide, okay, we want to jump in. Secondly, that doesn't have anything to do with her counterclaim. I want to point out that the court, in denying Rinker's motion to amend his claim and bring claims against the association, the court cited something to the effect that, oh, this case is 20 months old, and this is just too late. I mean, it was just a few months old before then that the case was 17 months old, and the court gave Ms. Colina Lee the benefit of a whole new trial. That probably would have happened. That probably would have been the correct outcome if the court granted Mr. Rinker's motion to amend. But again, there's a lack of parity here that the trial court did not treat the parties equally.
Didn't Dr. Rinker also represent in the motion for leave to amend that he could assert his claims against the association in a separate lawsuit?
Yes, Your Honor, we did consider that, and there was no guarantee that if we had done that we would have had a consolidated hearing on the issues. And we were also afraid that if we did that, we would upset the judge, honestly. That obviously is not in the record, but that was part of the strategy that went through our head.
But by telling the court that those claims could be asserted in a separate lawsuit, didn't that, in effect, tell the court that the association was not a necessary party in the pending action?
Well, I don't think that meant that we believe the association was not a necessary party concerning the construction of the association's founding document, and whether it was a necessary party on our counterclaims. I mean, obviously it was a necessary party if we were going to bring counterclaims for trespass and nuisance. Those would have been the claims that we would have asserted in a separate action. would just have been trespass and nuisance. Judge Furman, you asked if the association was asked to deal with this drainage problem, and the answer is yes. And it's in the record. I think there was testimony to that effect that that Mr. Rinker proposed solutions multiple times to the association to reshape the roadway, and the association never allowed them. And I want to finish up here with a point about whether is this an easement case or is this a covenant case? And I think it's a covenant case. And in that case, the Colina Lee had to prove all 4 elements for an injunction, and the easement cases are not applicable. And the Colina Lee's counterclaim was not that Rinker is interfering with an easement. Her counterclaim was Rinker's violating this specific provision of the road maintenance agreement, which is a covenant. Now, even if the judge in the trial court level was correct in bringing in easement law principles, I think the judge still didn't do it right. The case I would cite the court to is the Lazy Dog Ranch case, which comes up an awful lot in my practice. And that one of the messages of that case is that the burden on the if I could finish my thought, I see I'm out of time.
Sure, you can finish the sentence.
So if you have an easement dispute like this competing uses, you have to balance the burden of the dominant use on the servient estate. And in this case, the judge did not go through that analysis at all, and it basically granted a whole new property right to the association for a drainage easement onto Rinker's property. That's the effect of the injunction. That's
Thank
why
you.
it's too broad.
Thank you.
Your Honors.
Well, thank you to both attorneys for excellent arguments. The case will stand submitted, and a written opinion will issue in due course. We will now take a brief recess before we hear argument on the Wilhoit case. in the case of Wilhoit to the Industrial Claim Appeals Office. Please proceed, counsel, for the appellant.
May it please the court, Larry Saunders appearing on behalf of Mr. Wilhoit and registration number 21194. I think most of us, when we get hurt and we go see a doctor, we listen to our doctors, and we listen and we do what they tell us to do in the hopes of getting better. And that's what Mr. Wilhoit did here, and as a result, he ended up having his temporary disability benefits terminated. And that's why we're here, because we think that was fundamentally unfair. And on September 11, 2017, the day that the modified employment was supposed to start, Mr. Wilhoit had discharge instructions from his doctor that greatly conflicted with the modified job offer. And so Mr. Wilhoit thought he wasn't able to do that modified job offer because it would violate his discharge instructions from his doctor. And the administrative law judge found that, well, wait a minute. If you look at those discharge instructions from September 11, 2017, some of those are merely treatment recommendations, which you should have just ignored, and others were work restrictions, which you should have paid attention to. And when the administrative law judge did that, the administrative law judge never explained what he meant by treatment recommendations or how Mr. Wilhoit was supposed to know the difference between a treatment recommendation and an actual restriction that he's supposed to follow. The panel below us never defined it either. The best they could come up with is they looked at WebMD and they looked up the acronym RICE, which stands for rest, ice, compression, and elevation, and they said, oh, that's what the administrative law judge was referring to. But we know that's incorrect because the administrative law judge found that exercises that Mr. Wilhoit was told to do was also included as part of the treatment recommendations, and that's not part of the RICE acronym. So even the panel below us could not tell us what the heck the judge means by treatment recommendations, much less how Mr. Wilhoit was supposed to know what those are. So he's handed these restrictions, and he feels he can't do his job because if you look at the restrictions and you compare them to the modified job offer, they do conflict, and they conflict greatly. And I think also the statute, the modification of employment statute that is at issue here, I think when it was written, the authors never really thought about the circumstances in this type of case, where you start off, you get a doctor to approve a modified job offer, you send that offer to the claimant, and then before the claimant starts work, there's a material change in the medical condition. So the previous approval for the job offer, why should it apply then? That really doesn't make any sense. And on September 11th, we have work restrictions that include the back, which was never taken into account before on August 25, 2017.
And those work restrictions are, of course, conveyed to the employer on September 11th?
Were they conveyed to the employer?
Yeah, those additional work restrictions or newer work restrictions, were they conveyed to the employer on that date?
There was a dispute in the testimony that Mr. Wilhoit said he did call the employer, could not get a hold of, I believe, Ms. Northern in her office, left a message. She said she never got a phone call.
So the
Whether
answer was no then? They were not conveyed to the employer?
I don't know, because nothing in the record indicates that, but I don't know if the doctor's office would have sent it directly, like by fax, because sometimes that's what they do. And so that may have happened, it's just not in the record.
Are we bound by the administrative law judge's finding that Mr. Wilhoit didn't call the employer and thereby violated the employer's attendance policy?
Maybe not in this case, because it's very unique. And the panel agreed with me that right after the hearing ends, or shortly after the hearing ends, records closed, the respondents tried to get in some additional evidence, and they filed their motion. They indicate it's contested. I'm not agreeing to allow that evidence in. The judge, with it the very next day, grants that additional evidence. And even the panel below said that shouldn't have happened. It's a complete violation of due process. But then the panel goes on to say, well, it was kind of harmless. But if you read the judge's order, the judge is repeatedly saying, or when he looked at that additional evidence, and this is from a meeting that Mr. Wilhoit had with a doctor more than 2 months later. So the events at issue here occurred on September 11th. He sees the doctor, Dr. Primack, on November 14th. And based on what Mr. Wilhoit says at that time, what his work restrictions are, the administrative law judge says, well, I find that Mr. Wilhoit's not credible. He's not believable. And if you find that somebody's not believable, that affects your entire opinion. And I don't even think it makes logical sense that what Mr. Wilhoit would have understood his work restrictions to be more than 2 months later has any effect on his credibility on September 11th, but that's what the judge found.
But aren't we bound by the judge's findings on credibility?
I think under those circumstances, no, because he used improper evidence to get there. I think the case should be remanded, the judge should be told, ignore that evidence, and then, see what you think of on credibility. The other thing is the judge is also saying that he's not credible with respect to his beliefs regarding the work restrictions or the medical restrictions, which can be found on the record at page 170, page 98 of claimant's exhibits, despite the fact that claimant's understanding of the discharge instructions is perfectly consistent with what is actually written on the discharge instructions. So I don't know how you say that he's not credible when his understanding is perfectly accurate and we can check it for ourselves. So I'm not so sure that we do just automatically follow the judge's opinion on credibility in this particular case. And I also don't think there's any duty that Mr. Wilhoit had in the law that he had any obligation to give them the new work restrictions. I mean, probably would have been nice that he had so, but I'm not aware of any statute or particular rule that says he has to do that in order not to get his TTD benefits cut off.
Well, Mr. Saunders, let me, I guess, clarify something, if you would. Was Mr. Wilhoit responsible for his own termination?
No, not at all.
Did he contact his employer and say, I'm not coming to work?
That's what he testified to, and I said that the judge said he never made the phone call. But he's not responsible, and it's undisputed in the record because Ms. Northern, the only witness to testify in this case on behalf of the respondents, she testified and she said that it is against their company policy to terminate an employee for not showing up for a job that violates their work restrictions, or violates their restrictions. And that's actually the facts of this case. So there's no basis really to terminate his employment when the modified job offer goes beyond the work restrictions.
How does it violate the work restrictions if the employer doesn't know about them?
Well, it does violate the work restrictions, whether the employer knows about it or not. If the work restrictions are X and the modified job offer is something less than X, it's a violation. Knowledge of the violation is a completely different issue.
It's not knowledge of the violation, it's the knowledge of the restrictions. There's a difference.
Well, I think they would go together in this case. If you know what the restrictions are, you would know that the job offer is violating the restrictions. But regardless of knowledge, the violation would still be in existence. That would never change.
And how did Mr. Wilhoit determine that the bud trimmer position wouldn't be consistent with his restrictions, wouldn't accommodate his restrictions?
Right, he relied upon the written modified job offer that was sent to them, sent to him. And I think that was sent sometime around August 25th. And he could compare that to the written discharge instructions that was given to him on 9/11/2017 and see that there's numerous differences. For example, on that date, he'd have to rest on a firm surface, flat on his back with a pillow underneath his knees. There was nothing in the letter, and this was verified by Ms. Northern, that said he could do that. Same thing with needing to exercise and do stretches every hour. And the discharge instructions specifically says that this is essential for your recovery. Nothing in the letter that he was sent said he could do that. And what the administrative law judge did was he allowed in improper testimony. The statute says that the modified job offer has to be made in writing. And then Ms. Northern starts adding to the modifications and saying, oh, well, we would have done all sorts of other modifications. And I objected immediately, and I made that clear in the record. And the statute reads that the offer has to be in writing. The respondents are saying, I guess not all of it has to be in writing, but the statute doesn't say only part of it gets to be in writing, or says what part gets to be in writing, what doesn't to be in writing. Makes sense that all of it has to be in writing. So the administrative law judge, I guess, took the position that Mr. Wilhoit should have been a mind reader to know that, ignore the letter, that there's going to be additional modifications. And
Could
the law
the-
doesn't require him to do that.
Could the administrative law judge have taken the position that the employer has to be a mind reader to basically accommodate or rewrite the modified work conditions in light of conditions they don't know?
Well, yeah, absolutely, because why is it just to say that if we don't know what your work restrictions are, we get to violate them? I don't think under any circumstances an employer should be able to violate the work restrictions. And
Even if they've not been made aware of what those work restrictions are?
even if they're not aware of those work restrictions, because they have an obligation to find out what those work restrictions are. They communicate with the work comp doctors all the time. It's not just that Mr. Wilhoit is the only avenue that they get that information. And that's why I don't know if they actually did or didn't have that information, because I know it's common in workers' compensation cases for the work comp doctor to fax over reports to the employer. I see that happen all the time. But to say that if we don't know, we get to violate your restrictions doesn't make any sense to me.
I'm good, counsel.
Okay. And basically, the other point, well, I'll reserve my remaining time for rebuttal, if I may. Thank you.
Thank you. Counsel for the appellee.
May it please the court. I'm Harvey Flewelling, registration number 22605, representing the respondents Maggie's Farm and Pinnacle Assurance. So the issues raised by the claimant here is whether the Industrial Claim Appeals Office erred in failing to find the ALJ erred in allowing evidence that contradicted the written modified job offer and relying on it, and whether the Industrial Claim Appeals Office erred in overlooking whether there was a good faith basis for claiming to believe he could not do the modified job offer under the authorized treating physician's medical restrictions. Both of those issues, and the argument ignores the fact that the ALJ exercised his discretion and determined with substantial evidence supporting it that Dr. Bradley's work restrictions were complied with by the employer, and that Dr. Bradley approved the job description that the employer provided him. So claimant was released to this modified duty that was approved by his authorized treating physician. The job offer was made to the claimant with the doctor's restrictions attached to it, and the claimant failed to begin that modified duty. So under that statute, temporary disability benefits are terminated automatically for failure to begin the modified duty.
But let me ask you, what happens if, in between, the doctor's indication that the modified duty would have been adequate, what happens if the doctor identifies some more restrictions that are necessary? That, I believe, is the crux of opposing counsel's position.
Well, the doctor did not retract his approval of the modified duty job, number one. Number two, the ALJ found that what Dr. Bradley recommended for treatment, those RICE recommendations, did not constitute physical restrictions. Also, the problem with the claimant's back was found to be not related to the work injury.
How did the ALJ distinguish between what are work restrictions and what were recommendations or not work restrictions?
By looking at the medical records, Your Honor, where one section of the doctor's regular report, which he issued every time he saw the claimant, under his plan recommendations, he discussed those RICE recommendations, among other things, such as exercise, home exercise. Then, under work restrictions, he listed those: no lifting more than 5 pounds, sitting for 7 hours a day, standing, I believe, up to 1 hour a day. Those are the physical restrictions. As a matter of fact, and that's exactly what the August 25th, 2017 job description had, that there was no sitting, no carrying more than 5 pounds, sitting, I gotta read this, 50 minutes per hour, standing or walking 10 minutes per hour. There's nothing in the doctor's approval of the modified job that discusses these RICE-type recommendations.
Is it your position that an employer never needs to accommodate an injured worker's treatment recommendations?
Not necessarily, Your Honor. The case law in this talks about whether if the claimant, as a practical matter, cannot accept the modified job. So you look at whether the claimant was reasonable in not accepting the job or not showing up for work. And in this case, the ALJ found it wasn't reasonable, that this job, this modified job, fit easily within the claimant's physical restrictions.
Including the treatment restrictions, or treatment recommendations?
Well, it was a twofold type decision. He found that based on just the physical restrictions, the claimant was able to perform the job, and even if those treatment recommendations were considered to be physical restrictions, the claimant could perform that job. Also cited by the judge and ICAP and in my brief is the fact that the well-settled case law that the claimant's personal opinion on his ability to perform perform the modified job is legally irrelevant. It's the determination of the treating physician that is entitled to the deference there. That's the Burns v. Robinson Dairy case.
Mr. Flewelling, sorry to interrupt. Was Mr. Wilhoit responsible for his termination?
Yes, Your Honor, that's the finding of fact by the ALJ, and that even with if all the claimant's arguments regarding his treatment recommendations were taken as true, the fact is he did not call in to the employer at the time the modified duty job was to begin.
And that was undisputed?
It was disputed, but the ALJ found that claimant's testimony was not credible. He credited the testimony of Ms. Northern, who said that the claimant did not call in on 9/11/17 when he was supposed to begin his job, and that's the ALJ's prerogative to determine credibility. He found the claimant was not credible in that respect.
Do you agree that the employer has an obligation to communicate to the injured worker all material aspects of the modified job?
I think not necessarily, Your Honor, because I think the responsibility is to describe the job duties and whether they're within the restrictions provided by the doctor. The statute's fairly simple in that regard. I don't think the employer needs to consider every variable that the job may entail. For instance, if a worker, they're not going to say, we'll allow you a bathroom break whenever you need one. That's probably implicit in a job, that you're going to be able to, there's going to be accommodations made. And so I think there has to be some common sense in what a modified duty job offer would entail. And the ALJ here found it was in compliance with the statute, and so did the Industrial Claim Appeals Office. So if the claimant had merely called in, as Ms. Northern, she testified, if he would have just called in as the employer's handbook and policy required, but he was a no-show and a no-call for 3 straight days, and that's why he was terminated, and that's why he's responsible for his termination of employment. There's no further questions. That's all I have. Thank you.
Rebuttal?
Opposing counsel claimed that the administrative law judge found that Mr. Wilhoit was unreasonable in not accepting the job. There is no such finding. It does not exist in the record. And in fact, opposing counsel just contradicted himself. He went on to say the administrative law judge also found that it's irrelevant what Mr. Wilhoit thought his restrictions were. So the judge did find in findings of law, paragraphs J and K, that it was irrelevant, but ask yourselves, how could that possibly be when Mr. Wilhoit's understanding of the work restrictions were accurate? To say that an accurate understanding of his discharge instructions is irrelevant to consider, to take into account, doesn't make any sense. Now, it may make sense that if Mr. Wilhoit thought he couldn't even walk, where there's no findings at all that he's incapable of walking, maybe that kind of subjective belief is completely irrelevant because it's just too far removed from the actual medical restrictions. But when his belief is consistent with what the doctor is telling him, and there's no contradiction between Mr. Wilhoit's beliefs and the medical records.
Well, sorry to interrupt. Did Dr. Wilhoit, did Dr. Bradley retract his approval of the modified job?
Well, it depends what you mean by retract. I think he did, in essence, when he gives the discharge instructions on 9/11/2017, and it's far more significant than just getting bathroom breaks, saying you have to rest on a firm surface flat on his back with a pillow underneath him. He has to ice or heat his lower back for 20 minutes 3 times a day, things like that, that are definitely not in that letter. And it's customary in workers' compensation cases, the doctor gives the restrictions. Hardly ever do they give any notes to the employer what specifically can or cannot be done for the job. They wait until they get a question asked by the employer to give that kind of response. Otherwise, they just give their medical records and their notes, they hand that to the patient, and that's what they're saying should be followed. So to the extent that what happened on 9/11/2017 is inconsistent with his early opinion, I think that is a retraction. I don't know what else you really call it. It may not be a formal one, but it makes sense empirically that it's at least an informal retraction. There's certainly an inconsistency there. And then to say that, well, the back's not related, the problem with that is, at the time, there was no indication the back wasn't related. The first we hear that the back isn't related is more than 2 months later when he sees Dr. Primack on November 14th. So how is Mr. Wilhoit supposed to be able to predict the future? And it may turn out that the back is still covered under this case because that issue hasn't been finally decided yet. Mr. Wilhoit will have an opportunity to do what's called a dime in this case. And if the dime physician determines that the back is related, it's probably related. So does that mean then we get to come back again? Or should we just look at the facts that were in actual evidence that Mr. Wilhoit could have known about on September 11, 2017 and decide the case that way, which would make a lot more sense than saying that Mr. Wilhoit should have been able to predict that months later the back wouldn't relate it. And even if the back isn't related, it's still a restriction he had to follow, whether it's work-related or not.
Thank you.
Thank you.
Thank you to both of you for excellent arguments. The case will stand submitted, and a written opinion will issue in due course. The court will be in recess.